So some examples of copyrights, there's all the obvious ones that people know about. You know, you can get a copyright for artwork, photographs, paintings, books, music, movies. Everybody knows. They've watched the movie and they've seen the FBI copyright warning at the beginning. You know you can get copyrights for those. More modern examples are websites, blogs, ebooks. I think somebody had a question about whether you could copyright an online magazine, and yes you can. Other examples, more non-conventional, but these are also subject to copyright, are things like menus, a restaurant's menu. Not the facts on there now, if it just says hamburgers and fries, but the general layout of the menu may be an original expression of an idea for a menu and therefore may be copyrightable. Brochures for your business. Advertisements. You advertise in the yellow pages, these banner ads that you can put up on websites, any sort of advertisement. Even business cards, if you have enough unique, if you have a unique design to your business card, you can actually have copyright protection in the layout. So all of those might be copyrightable. So who owns the copyright? Well, the copyright always vests initially with the author. So if you wrote a book, you'd own that copyright unless it was a work made for hire, and that's where your employer is going to own it. But in order for the employer to own a copyright, it has to be prepared by an employee as part of their employment. So if you're employed at McDonald's serving hamburgers and you write a book on the side, McDonald's probably is not going to own the copyright to that because you weren't hired to write that book. Or specially commissioned works. And what that means is that a business agrees, they hire you up front, they agree in writing that you are going to write this manuscript for my business in exchange for this amount of money, and then it's a specially commissioned work and the copyright automatically vests to the business that was paying you for it. Has to be agreed to in writing, has to be agreed to in advance of starting work on it. The business can't come to you afterward and say, oh, I really like your book, I want ownership. You can transfer ownership, but it doesn't automatically vest in the employer or that business. It's important to keep in mind that co-authors can be co-owners or are co-owners. So be careful who you work with. If you're writing a book and you're having somebody illustrate it, they're going to be a co-owner in the copyright. And if you can't pull the two apart, you may be able to take pictures out of the book and then you still own the copyright for the text. But be careful, because if it's so intertwined, if you're both working on designing it, they'll have just as much an ownership right in the final copyright that you have, and they can go do whatever they want with their copyright, sell it, license it to others. And so just be careful who you're working with if you have a co-author. Who does not own a copyright? Mere ownership does not transfer copyright. And I always give the example of buying a book. So if you go to Barnes & Noble, I was going to say Borders, but I think they're out of business now. If you go to Barnes & Noble and you buy a Harry Potter book, you actually own the physical copy of that textbook. You do not own the copyright to Harry Potter or the trademark or anything else. You can take that book, you can mark it up, you can resell it, but you cannot make copies and sell it, nor can you make what are called derivative works of that. In other words, read the Harry Potter book and make your own little story that falls off of some of the characters there. That might be considered a derivative work. People ask me sometimes, well, I bought a painting, or I bought these pictures. For example, when you go to if you go to a photography studio and get family pictures, there's usually an option to buy the negatives. Used to be the negatives, but now you'll get the electronic version of it, and the right to make copies of it. If all you do is you buy the 8x10 print, all you're buying is that 8x10 print. If you go and make your own copies of it, you may be violating the copyright. An example is people will come to me, they'll say, I bought these 10 photos and I want to put them into a book. into a coffee table book. Can I do that? Probably not unless you bought the copyright. And people will say, well, I bought the photos. But buying the photos is not the same as buying the copyright. So you always want to make sure that you have the copyright before you go do something with that, or you can find yourself in trouble.